What happens when a promise is tied to a single condition, and the other person starts performing that condition only for tragedy to strike? Can the promise be revoked? The 1952 case of Errington versus Errington and Woods shows us how the law protects those who start performing under a unilateral contract. Background story. In 1936, a father bought a house for his son and daughter-in-law. The purchase was financed with a mortgage. The father told the couple, "If you pay the mortgage installments, the house will be yours." This was not a formal contract signed on paper. It was an oral promise with a clear condition. The couple moved in and began paying the mortgage regularly for years. The arrangement worked without dispute. However, the father later passed away, and the property passed to his widow, the son's stepmother. The stepmother, Mrs. Woods, demanded that the couple leave the house. She argued that there was no binding contract giving them ownership rights. The daughter-in-law refused to leave, claiming she was still performing her side of the agreement by paying the mortgage. The matter went to court, raising a question central to contract law. Could the stepmother revoke the father's promise after the couple had begun performance? IRAC method case breakdown. Issue: whether a unilateral contract, once performance has begun, can be revoked by the promiser before the promisee has completed the performance. Rule: in unilateral contracts, the offeror makes a promise in return for the performance of a specific act, rather than a reciprocal promise. The general rule is that the offer can be withdrawn before the performance begins. However, once the promisee has started performance, the offer becomes irrevocable as long as the performance is completed within a reasonable time. Equity will intervene to prevent revocation if it would be unconscionable. Application: the father's statement, "If you pay the mortgage, the house will be yours," was a unilateral offer. The couple accepted the offer by starting to pay the mortgage installments. Once they began making payments, they were entitled to complete the performance without interference. The court held that the offer could not be revoked by the stepmother because the performance had already begun. Lord Denning, in the Court of Appeal, emphasized that equity would protect the couple from eviction as long as they continued to pay the mortgage. The promise was not a full transfer of ownership yet, but it created an equitable right that the court would enforce until the mortgage was paid in full. Conclusion: the court decided in favor of the daughter-in-law. The stepmother could not evict her as long as she continued to pay the mortgage installments. This decision reinforced the principle that in unilateral contracts, once the offeree has begun performance, the offerer cannot revoke the offer. The case of Errington versus Errington and Woods has become a cornerstone in contract law for illustrating the protection given to parties performing under unilateral contracts. It blends contract principles with equitable fairness, preventing injustice when one party has already committed time, effort, and resources in reliance on a promise. It also serves as a warning. In such agreements, starting the performance locks both sides into a moral and legal commitment. The law will not allow someone to pull the rug out once the work has genuinely begun. If you enjoyed this case breakdown, press the like button, subscribe, and click the notification bell so you do not miss future case analyses. For more IRAC case studies and memorable legal stories, check out the playlist linked on your screen.